To banking, financial services, and pensions. We have a couple of studies today, and as a preview, we got one tomorrow, and then at least two more meetings this month with studies. So thank you everybody for coming. I know there's some folks that will be streaming this. If you're a legislator on the committee and you're watching remotely, if you want to text one of us that you see in the room, we'd be happy to get your questions in at the appropriate time. I understand, Representative Maynard, that you want us to hold questions to the end of the presentations if possible. We'll do so. So with that, Representative Maynard, you are recognized for your study on the impact of Article 8 of the Oklahoma UCC, which you'll have to even explain what that means to most people. Thanks.
Well, thank you so much, Mr. Chairman. And good morning. Thank you, everyone, for joining us, whether you're online or in person. It recently came to my attention that there were some concerns with Article 8 of the Universal Commercial Code and the potential impact that these rules could have on personal property rights of Oklahoma citizens. So here are the concerns that have been expressed to me. So under Article 8 of the UCC, when you buy a stock through your banker or a financial institution, you actually do not own the stock itself unless you take physical possession of it, which very few people do anymore. So what you actually own is called a security entitlement interest, with the bank or financial institution actually being the owner of the underlying stock. So based on a few exceptions that are in Article 8 of the UCC, it has been expressed to me that it could be possible for a creditor to have a preferred interest over you in the event of a large stock clearinghouse going through bankruptcy or going under. So these are the concerns I've heard expressed. So based on these potential concerns, I wanted to host this study we have today to hopefully accomplish two things. So number one, to inform the public about how stock and securities ownership actually works. And number two, to kind of evaluate if there are any potential legislative changes needed to the Universal Commercial Code to better protect the personal property rights of our citizens. Now, I do not pretend to be an expert about this topic at all, which is why I've invited our various guests today to help present. But before I turn it over to our in-person guests, I did reach out to the Universal Law Commission, who is the one who drafts the Universal Commercial Code, to ask about this, and they did send a letter to the committee. So I'm going to read some of this letter just to get their statement into the record, because unfortunately they couldn't be here to present, but they did at least want to send their opinions on the UCC Article 8. So everybody should have a handout with them which has this letter. There's also a second letter that was submitted to us by SIFMA. Just due to the interest of time, I will not be reading that, but please take time on your own to read through that as well. So Article 8 of the UCC governs transactions involving investment securities. It was drafted to operate in conjunction with federal securities law and regulations to facilitate interstate securities trading and protect investor interest. The UCC is periodically updated by its sponsoring organizations, the Uniform Law Commission and the American Law Institute, to keep pace with evolving market practices and technological developments. The most recent update to Article 8 was approved in 1994 and recommended to state legislatures for adoption. The Oklahoma State Legislature adopted revised Article 8 the following year, and by 2001, every other state had followed suit. The 1994 revision to Article 8 was necessary in part because of changes to the way in which most investors hold securities. Investments like stocks and bonds used to be issued on paper certificates. To sell a security, an investor had to endorse the certificate by signing it on the back and deliver the paper to the buyer. As trading volume increased, this system became untenable, and brokerage firms began to offer their customers computerized trading through a system of indirect holding. Over time, the direct holding system for investment securities was adopted the indirect holding system for investment securities was adopted by most investors and the firms that serve them because of its many advantages over the direct holding system. The securities markets that exist today allow for near instantaneous trading, one-day settlement of trades, consolidated brokerage accounts, and many other efficiencies and conveniences that would not be possible in a market using paper certificates. The 1994 revision of UCC Article 8 included a new Part 5 titled Security Entitlements that sets out the rights and obligations of investors using the indirect system for holding securities. This law, which has operated effectively since 1995 on behalf of Oklahoma investors and businesses, has recently been criticized because of a misunderstanding about its investor protections. Specifically, the rules in UCC Section 8-511 that govern priority and security interest have been misinterpreted as harmful to the property interest of individual investors. Priority rules exist to settle conflicting claims. If more than one party claims an interest in the same securities, something has gone wrong with a transaction. One party has failed to deliver cash or securities to complete a trade. When that happens, the priority rule determines who receives the security and who must pursue another remedy, such as an insurance claim or a lawsuit. The misreading of 8-511 is understandable because while the general rule in subsection 8-511A grants priority to investor owners over creditors, two exceptions in subsection B and C give priority to creditors over investors in particular circumstances. In fact, the misreading of these rules was predicted in a law review article published in 1996 by Professor James Rogers, who served as the reporter for the drafting committee that produced the 1994 revision of Article 8. He explains how and why these exceptions to the general priority rule actually protect individual investors. To summarize, Professor Rogers, critics of these rules make some faulty presumptions. The first is that creditors are large financial institutions. In fact, the creditors granted priority under these exceptions are often individual investors who authorize their broker to lend the securities they own to other investors. Or they may be institutional investors, including pension funds and the Treasurer of Oklahoma, who invest on behalf of many individuals. This lending of securities provides additional opportunities for investors' profits, and it is strictly limited under both the UCC and federal securities law to investors who voluntarily assume the increased risk. Conversely, the investors whose interests are subordinated to creditors under these exceptions to the general rule are often large financial institutions. The second faulty assumption is that individual shares of a security are traceable to a particular transaction. Under the indirect holding system that exists to facilitate computerized trading, securities are held by brokerage firms and clearinghouse pools for the benefit of individual investor accounts. At the end of each trading day, all of the trades involving each particular security are settled, and shares are reallocated from the accounts of the sellers to the accounts of the buyers. But it would be impossible in most cases to identify any particular share of a stock or bond as changing hands in a particular trade. The investment firm's obligation under the law is to hold a sufficient total number of shares of a security to satisfy the claims of all of its investors, not to determine which shares from the pool belong to which investor. Finally, critics make the faulty assumption that these exceptions giving priority to creditors benefit large financial institutions rather than individual investors. In fact, large financial institutions do not just trade securities for their own accounts, they trade securities on behalf of their customers. The priority rules under UCC Section 8-511 exist to limit systemic risk when something goes wrong. If a single brokerage firm fails in its legal obligation to settle trades by delivering cash or securities, it is not only the failing firm's customers who potentially suffer a loss. It is not only. The investors from one brokerage firms who are counterparties to the failing firm's trades could also face losses. The priority rules in UCC 8-511 serve to protect investors by containing the losses to the firm that failed, rather than allowing a chain reaction that affects customers of other firms. Securities law is a complex topic that is easily misunderstood. The same critics that object to Article 8's priority rules have raised other concerns that also have no basis in fact. So, with that being read in from the Universal Law Commission, I want to now turn to our live presenters who have come. The first one we have up for our talk today is David Webb, who is the author of The Great Taking. He actually flew all the way in from Sweden to come present in person to us today. So, David, thank you so much for being here, and the floor is yours.
Yes, thank you. And I want to thank you for the opportunity to speak to you about this. So in the interest of time, I'll just get right into this. So what we're talking about here is certainty of control of the collateral. That is what has been shifted here. That is what has changed. So for 4 centuries, securities were personal property. Now, the beauty of that was that the public was really absolutely bulletproof then in the event of failures in the financial system, because it was your property and you could revindicate or take back that property, and if it was not returned to you, that was criminal. That is what has been changed. Certainty of control has been shifted elsewhere within the financial system. The thing that is certain is that the public does not have control of their own investments as collateral. So let's get into how that happened. The first step was dematerialization, and this was a process beginning in the early 70s. And there's interesting history to that. I'm not going to take the time to go into that, but this established what's termed the indirect holding system, where your securities are not held at your broker. They are held at a higher level within the financial system. So you no longer have a direct property interest in a specific security. You have an appearance of ownership, which is termed beneficial ownership. This is an appearance of a property right. You receive the dividends. You can, of course, decide to buy or sell the security. You can vote a proxy, but it does not function as a direct property right in the event of insolvency. That is the key change that has occurred. So the use of all of this pooling of securities, this is what has enabled the fantastic growth in the derivatives complex, is the use of the public's collateral, free of payment, literally free of payment. So these are the key facts. Ownership of securities as property has been replaced with this concept of a security entitlement. This was a newly created invention in the 1994 amendments to the UCC. It had never existed in 400 years of securities law. You're told that this is a property interest. It functions like a contractual claim. Further, all securities are now held in unsegregated pooled form, and we'll get into confirmation of that. So securities used as collateral and any securities where the client has been told that their securities are not being used are in the same pool. So this is the subterfuge. There's no distinction as to whose securities are being used. So all the securities are being used as collateral. The investors, and this is small investors, this is sophisticated investors, this is institutions, pension funds, are only entitled to a pro rata share of what remains in the pool after the secured creditors take their collateral from the pool. There is no right to re-vindicate, to take back one's own securities, because there's no specific identification from the investor to a specific security. This is by design. All of these securities can be used without restriction and free of payment, FOP. Then further, in 2005, safe harbor was established to assure that secured creditors take these securities ahead of the account holders, even if there was fraud involved. And we'll get into how you know that. And this has been upheld by the courts. So we have established case law that that is how that will work. So how can we know this? After this was implemented through the UCC in the US in '94, at the behest of the banking interests, this was then pushed globally via the US State Department. And the Europeans, the EU, was being pressured to conform to this approach and really to subvert ancient property law in Europe. They established something called the Legal Certainty Group. Now that sounds nice, legal certainty, but what they mean is making it legally certain that the secured creditors keep the collateral in the event of insolvency. So we have the fine work of the Legal Certainty Group, fortunately. So they then sent a questionnaire to the Federal Reserve Bank of New York. So this is a primary source document. It is historic. It is absolutely irrefutable. So it's a detailed questionnaire as to how does this operate. Explain it to us so that we can copy what you've done. And the response is from the Deputy General Counsel of the Fed. So there is no more definitive source for this. This is conveniently ignored by the Uniform Law Commission in their letters. They will not acknowledge that this document even exists. It's in full in the appendix to this book, The Great Taking. So, question, in what respect are these answers given? Specifically, we're talking about Article 8. So I would direct you to this. We have the most valuable document you could see explaining how this actually operates, and that this has been adopted throughout the US. So where securities are in pooled form, does the investor have rights attaching to particular securities? Simply no. Now, this is the important thing. This is true even if investor positions are segregated. So sophisticated institutional investors want to believe they can assure their clients that their accounts are segregated. Through this indirect holding system, this is totally subverted. It is, and so we have a definitive answer on that. So is the investor protected against the insolvency of an intermediary? An investor is always vulnerable to an intermediary that does not itself have sufficient entitlements. Now, we'll get into how do they end up with more entitlements than the entitlements of the investors. We'll get into that. If the secured creditor has control, it has priority. And this is what you see under this exception in the UCC that gives the secured creditor of the intermediary priority if they have control. Now, control is a concept from bankruptcy that simply means a party has control if it has the ability to sell the asset. And within the indirect holding system, that ability to control the asset and sell it is held elsewhere all the time. It's not held by the client. These pooled securities are used constantly and many, many times over. And then this other exception, which you will find in the UCC, that if it is a clearing entity, its creditors always have priority. This is what is really operative. So what rules protect a transferee acting in good faith? And then they switch to this term, Article 8 protects a purchaser. Now, what they're referring to here is, think of a swap contract. What a swap is taking a treasury security and effectively selling it and getting the funds under a short-term contract, where it's a repo agreement, a repurchase agreement. It's a means of short-term borrowing used massively in the financial system. So Article 8 protects the purchaser under these swap contracts. That is the party receiving the pooled asset, the pooled security. So it's all about, and that is how more entitlements are created than the investors' entitlements. So once these pooled assets are used under swap contracts or extended as collateral under derivatives trades, they enter the chain of use and reuse of collateral within the financial system. So they're used, the party that has received the control of the collateral then extends that collateral again under another trade. These collateral chains are attenuated. They're very long. So Article 8 protects the purchaser against claims of an entitlement holder to a property interest in their own property. That's what Article 8 does. The Fed makes it absolutely clear, limiting the entitlement holder's ability to enforce that claim unless the purchaser was involved in wrongdoing. Now, what we will see in the case of Lehman Brothers is, even if there was constructive fraud, there's no ability for the client to reclaim the asset. So so how are shortfalls covered? The only rule is the entitlement holders share pro rata. So the parties that have received the property under a contract keep the property, and the clients, the entitlement holders, just get a pro rata share of what remains. And in fact, this does not generally matter unless we're dealing with insolvency. That's when it matters in a big way. So they make that clear here. So does the treatment differ if there is fault, fraud, negligence, breach of duty? Regardless of fault, fraud, or negligence of the intermediary, the entitlement holder has only a pro rata share. So now this is very important. They want you to think that with a modern indirect holding system, that things couldn't be otherwise, that you have to acquiesce to this because it couldn't work otherwise. When Sweden was forced to dematerialize, Sweden implemented this the way you would like to see it done, where there was specific identification of every investor to every security electronically, and the system worked flawlessly. This was the model for the world, the Swedish system, Sweden and Finland. But the legal certainty group identified Sweden as being problematic because Sweden was not assuring certainty for the secured creditors to keep the asset. So there was a long process to subvert the system in Sweden and Finland, and they've done it. So the system in place in the U.S. it took some decades, but it has now been forced on the world globally at this point. But this is very important to know that a choice was made here to do it this way to assure protection of the secured creditors over the protection of the investors. It did not have to be done that way. So the ULC makes mentions of James Rogers, who was the drafter, essentially the guy who wrote the amendments. And this is a very important paper, Policy Perspectives. So he says, these are quotes from that, concerns have been expressed about the protection of interests of individual investors. He's writing at this point in 1996. So while they were rolling this out through the states. Concerns that the secured creditors of the intermediary that have wrongfully received these securities will still have priority over claims of the customers, even if the collateral has been used wrongfully. This gets back to the fault, fraud, or negligence, that does not matter. He says this was given very careful consideration by a very large number of thoughtful lawyers who started from the standpoint of unease. So they knew that this was being done at that time in 1994, 1996, and that after careful consideration, they decided it was entirely sound to give the priority to the secured creditors of the intermediary. Now, we'll get into the rationale for this is that you have to do that or the whole system will collapse. You know, you have to let the secured creditors keep the client assets. That's really the rationale. So the idea that this was done in the public interest or to protect investors is completely untrue. And he makes this statement that this was about Armageddon planning, what would happen in a major systemic collapse. And that's what we're looking at. And that there were interests in both governmental bodies and private sector groups. These private sector groups were the banking interests, very plainly. There were no consumer protection groups involved in this, contemplating what would happen in the event of a major crisis in the financial system. This was what this was about. So historically, I've touched on this, if assets of clients were used on the eve of a bankruptcy, it was possible to, these were constructively fraudulent, and it was possible for the bankruptcy trustee to claw back those assets. But this is an example of how this was worked to make it certain that the secured creditors would keep the assets. So these safe harbor provisions were expanded in 2005, and this was done to assure safe harbor for the secured creditors against claims of customers to their own assets. So what was previously considered fraudulent can no longer be challenged. And these are statements by Stephen Lubin, who has some expertise in this area, that now all derivatives contracts have this special treatment where collateral extended under a derivatives contract cannot be challenged. And that this covers all swap contracts, and essentially the whole of the derivatives market is protected in this way. It cannot be challenged under safe harbors. But, and this directly contradicts what the ULC is saying, that this is about protecting individual investors or pension funds. It is clear that only a protected person has this super priority, essentially only the very largest financial institutions, essentially the globally systemically important banks, the GSIBs. So now Lehman Brothers, this is hugely important in demonstrating all of this. So JP Morgan was both the custodian and the secured creditor that took the client assets. So they're acting as the custodian for the clients in one entity, and in another subsidiary, they were on the other side of these swap contracts that took the client assets. So this would have been considered constructively fraudulent. So now it's important to understand that the assets that were taken, these were big institutional clients. Imagine you're in the teeth of a financial collapse. They had mainly treasury securities as their dry powder, their collateral. And unbeknownst to these sophisticated clients, their treasuries were being used by Lehman under swap contracts with JP Morgan. This is what happened here. So this decision of the bankruptcy court is 5 years after the collapse of Lehman Brothers. They still have not recovered their collateral after that length of time. And this is quoted directly from the decision. The court agrees with JP Morgan that the safe harbors apply here and must be applied literally in the interest of market stability. So this is the idea that JP Morgan has to be protected in taking the client assets or the financial system will collapse. This is the rationale, the imperative. This is precisely the sort of contractual arrangement that should be exempt from being upset by the bankruptcy court. And this is a transaction between sophisticated financial players. The clients had no idea that they had not pledged these treasuries. They had no part in this transaction. But this is the precise setting for which the safe harbors were intended. The court must first consider whether JP Morgan is eligible. So safe harbors apply only to certain types of entities. And this is in the opinion itself, the bankruptcy opinion. Quite obviously, JP Morgan is a member of the protected class. They use that term in the opinion. So it's not your pension fund that is going to be protected. It is only the biggest banks that will be protected in this way with this priority. So remember this again, an investor is always vulnerable to an intermediary that does not itself have sufficient entitlements. This is how the additional entitlements are created, by using the pooled assets under the derivatives contracts. So JP Morgan knew that these were customer assets that were being used. They were also the custodian for the client assets. They had control of the client assets. And the Uniform Law Commission tries to create the impression that there are all kinds of protections that would not allow this. Clearly, that is not the case, because no one was prosecuted for this. In fact, the court determined that this was entirely appropriate. So this would have been a constructively fraudulent preference transfer benefiting an insider, but that is no longer a claim that can be made by the client. So then this is another very important primary source document. It's a Bank for International Settlements report on cross-border mobility, showing movement of collateral from the collateral giver, and they use that term, to the collateral takers. So again, this is not like reading an article someone has written about this. This is a Bank for International Settlements primary source document. So these are statements from that document. The desired end goal is to get a single view of all available securities in real time. Then this information is a necessary prerequisite to deploy all available securities to meet collateral obligations. This system automatically then generates the collateral allocation instructions for the transfer of collateral from the collateral givers to the collateral takers. And they make this statement that existing collateral will not be sufficient. Now, what they mean by existing collateral is high-quality government bonds and cash, which is what is being used over and over again now. What they're talking about is that other types of collateral, i.e. equities, will also be needed. So market participants may need to exchange ineligible securities to fulfill their collateral obligations. This is what is termed collateral transformation. So again, this is basically exchanging under a derivatives contract equity securities for government securities so that they are theoretically now usable as collateral. In times of market distress, this must be done rapidly and will be crucial in mitigating systemic issues. So it will be automated. It happens without human intervention. So rapidly deploy securities to meet margin needs. Now this is where it's going. It's at the central clearing counterparties. CCP is not the Chinese Communist Party in this case. Central clearing counterparties, and that this will have to be done during a crisis. I think we're going to have one. So this will be done on a market-wide basis. Now this is a chart you can find in this document. It's in the book. What you see up at the top is supply with the collateral givers. Down at the bottom, demand is the collateral takers, and that's where the central clearing counterparties are. That's where all of the derivatives complex is concentrated. You see up at the top that equities are being used. This is just one example chart. So they're envisioning use of all securities. Now, central clearing, this 2008-9 financial crisis was used for an imperative to centrally clear all derivatives. What they said was that having a counterparty is too risky, so we need to centrally clear. In reality, this is an inversion. When there were counterparties, these were arm's length transactions. For every winner, there was a loser, and in theory, it could all settle down to net out to zero. But by centrally clearing all derivatives, it is all on the balance sheet of the central clearing counterparties. A pension fund, for example, doesn't have a contract with an arm's length contract with another party to hedge the market risk of a decline. The pension fund's contract is with the central clearing counterparty. So if the central clearing counterparties fail, there is no protection. And you'll see that they are designed to fail. So, and this, again, we'll revisit this. If the intermediary is a clearing corporation, its creditors have priority over the entitlement holders. What are the central clearing counterparties? They are clearing corporations. Creditors behind these contracts with the central clearing counterparties have priority to the pooled assets, but only if they are the biggest banks, the globally systemically important banks, not your pension fund. They are not protected in this way. So The central clearing counterparty combines the exposure to all clearing members on its balance sheet. Now, for example, depository trust in the U.S. houses the entire securities complex of the United States and much of the world. It operates two of the biggest central clearing counterparties. The entire capital base of depository trust is $4.1 billion. So now what you find, there are primary documents with participants in this system, both the central security depositories and the central clearing counterparties, talking about the prospect of failure of the central clearing counterparties because there's no capital base behind them. Now, DTC itself says that it is opposed to pre-funding more capital to protect against losses, but they are pre-funding the startup of a new central clearing counterparty. Now, what does that mean? They're going to let the existing central clearing counterparties fail. What does that mean? There is then the secured creditors behind these contracts take the collateral when those central clearing counterparties fail. So these are statements from DTC documents. As we go through our planning, we've determined we're going to pre-fund startup of a new central clearing counterparty. We definitely see the logic to start up a new one. Now, this is what I'm explaining. When we had securities where we had direct property interests in those securities, whether it was done electronically as it was done in Sweden, or when it was in a paper certificate form, which was a chattel, which the investor could use to secure financing because it was their collateral. You know, margin accounts existed for centuries. People could use their own collateral. Having a margin account was not something that was new with the 1994 revisions. So people had property. What has been done is to turn their claim into a contractual claim, which is worth nothing in insolvency, but to give certainty, absolute priority to just the biggest banks. Now, this is the irony. They're doing that under contracts, which never would have been had that kind of a priority claim in insolvency. That's why they had to make these legal changes. This is a very sophisticated plan that has been implemented over decades. So let's see. I'll get into some comments, time permitting. So SIFMA, this is from the SIFMA letter from Andy Guggenheim. Regardless of whether ownership is demonstrated via electronic certificate or on paper, the customer's property rights remain the same. That is an absolutely untrue statement, I think you can see now. Holding in street name in no way diminishes a customer's ownership rights. Absolutely false. Investors who choose to hold their securities in street name with their brokers are protected by a range of regulations, ensuring that assets are appropriately controlled and segregated. Again, I think you can see this is not the case. What they're saying is from the assets of the broker, this is the subterfuge. The books and records of the broker, the federal regulations are about maintaining the records so that they're separated on the books of the broker. That's not where the assets are held. They're not at the broker. They are held in the indirect holding system. They're pooled at a higher level. And this is designed to separate the claims of the clients against their broker from the assets which are held elsewhere. These securities cannot be borrowed, lent, or traded without the customer's consent. it's being done hugely. So that is not operative. Now here are comments from the ULC. This was a letter from March of this year. Proponents of the legislation have said that the provisions allow the intermediary to assume ownership of the customer's investment property, and that this is false. This is really a misstatement of what is being said. It is secured creditors of the intermediary that have control. So they've misstated this and then said that what we're pointing to is false. This again is from the ULC. So an investor has a property interest. It is not subject to the claims of the intermediary's creditors. Absolutely false. Investors will not lose their assets even if the intermediary becomes insolvent. They are completely ignoring what happened in the case of Lehman Brothers. So you cannot rely on these statements coming from the Uniform Law Commission. Again, from that letter, although the secured creditor has priority in collateral under the limited circumstances in these sections of the UCC, the secured creditor, if the secured creditor is acting in collusion with the brokerage firm to defraud the firm's customers, they could set this aside and recover their investments. We see in the case of Lehman Brothers that the bankruptcy court absolutely supported J.P. Morgan in keeping the assets. We can see in James Rogers' statements in 1996 that they knew that even if the securities had been used wrongfully, that the design of this system assures legal certainty and finality to the secured creditors. So these statements from the Uniform Law Commission, they are ignoring the response from the Federal Reserve to the legal certainty group. They are ignoring the bankruptcy decision in the case of Lehman, and they are ignoring, frankly, the comments of James Rogers himself, the drafter of the amendments in 1994. Intermediaries are required by law to hold sufficient entitlements. They're not permitted to pledge their customers' investments as collateral for the firm's borrowing. They are subject to civil damages, severe criminal penalties. We see that absolutely did not happen in the case of Lehman Brothers. Finally, although the secured creditor has priority, which they're now acknowledging, if the secured creditor is acting in collusion with the brokerage firm to defraud customers, this could be set aside. And again, Lehman Brothers shows that is not the case. So one statement they will make, when we've testified about this previously, they say two things: that there has been no change in property rights, which is manifestly false, and secondly, that this is about margin accounts, investors being able to have margin accounts. And it's clearly not about that from what I've shown you. There is a much bigger objective behind this. So they're saying that if you change this, clients won't be able to have margin accounts anymore, which is a pretty absurd statement, because for centuries, if you think about it, if you control your own property, then you have control of it as collateral, and you can secure a loan using your own collateral. We have a situation now where essentially everyone's investments are being pawned all the time. They have control of everyone's investments all the time. So I guess I made that comment there. I'll stop and pass it over to Don if that's, or do you want to?
Yeah, no, thank you very much, David. And Next up, we have Don Grande with us, who's an attorney. He's also with True North Public Policy, who is a private practice attorney who specializes in the UCC. So, Don, you are recognized.
Thank you. Thank you, Mr. Chairman, members of the committee. My name is Don Grande. I'm a private practice attorney. I've been working on this for quite some time. And David Webb provides a pretty significant overview of the complexity of the issue of our current financial markets. I'm going to focus on Oklahoma and your Uniform Commercial Code statute so we can look at what's actually in black and white. I'm a big believer that words are used in statute for a reason and other words are not used for specific reasons. So I think we'll get into that, and hopefully it'll kind of tie some of what Mr. Webb has talked about into why are we here talking to Oklahoma. So most of this information's already been gone over, but the amendments that passed in 1995, or they passed in 95, went effective in February of 1996, did have a significant change in property rights, regardless of what others may say. So basically the way we have summarized it is that every time an Oklahoma citizen has called their broker up, wanted to buy 100 shares of Apple Computer, they didn't receive 100 shares of Apple Computer. They received a security entitlement related to those 100 shares. So they didn't get what they thought they got. They don't own what they thought they owned. And I'll explain that. So first of all, a few definitions are important because unless you're really into the Uniform Commercial Code, and I don't recommend it, it's really something. But there are a few, and I apologize for having to look this way, a few definitions that are important. Clearing corporation, as Mr. Webb talked about, is defined in your statute. This is Title 12A, Section 8-102, General Definitions. Clearing corporation is a clearing agency under the federal securities laws. It's registered. There's 8 or 10 registered clearing agencies, primarily DTC and its subsidiaries. Could be a Federal Reserve Bank, which is an interesting thing we have to dig into a little bit, or any other person that provides those types of services. So that is a clearing corporation. Entitlement holder means the person identified on the records of the securities intermediary as the person having the security entitlement against the securities intermediary. So you're no longer a shareholder or a bondholder, stockholder. You are an entitlement holder. So it's an entirely new definition, and they flip around. We'll get into what a securities intermediary is, but it's basically your broker or financial advisor, your broker or the custodian that your broker or financial advisor uses, second level custodian, third level, all the way up ultimately to depository trust. So you become an entitlement holder when your broker enters that trade on their system. That's the only place that your name shows up in this entire chain. By the time it gets to the broker level and DTC, your name doesn't show up anymore. It would be in the name of the broker or of the custodian. So entitlement holder is important. That's who the investor is. Securities intermediary is a term that they throw around a lot, and they'll flip back and forth a bit because it covers both your broker, your investment advisor, that'd be the first tier, the person that you have a relationship with, but securities intermediary also includes custodians, higher level entities in the financial system, all the way up to depository trust. So it gets confusing because sometimes they play word games with us where they'll use the word broker when they want to say something specific, but then they'll flip back to securities intermediary. As Mr. Webb just pointed out, our primary concern isn't with the broker-dealer level, it's with the custodial level, the higher level securities intermediaries, because me as an entitlement holder, I have no contractual right, I have no ability to go after the custodian. My only access to legal recovery is with the broker. So security entitlement, again, this is the nut. This is what you, as an investor, receive in the indirect holding system. It was determined by the drafting committee as a sui generis right, which I don't use Latin a lot in my practice, but I had to look it up. It means of its own kind. So they conjured up a new type of right, sui generis right, and that's what a security entitlement is. So getting back to what Mr. Webb had said, the statement that it's exactly the same as holding a physical security is clearly false, because they've got a whole chapter dealing with what it is. And the previous sections 2, 3, and 4 deal with physical certificates by and large. So the drafting committee also identified the securities entitlement as a bundle of personal rights you hold against your broker. As an attorney, when I hold a bundle of rights against someone else, that's a contract. It's not a property right in the way I was taught. It's a contract, and that becomes important as we go. So I wanted to just get into the specific portions of your statute so we can just look at the black and white. I should add the yellow highlighting is not on your statutes. That's me. So that was more for my benefit. So we start out with Title 12A 8503. And this one starts out with property interest of an entitlement holder. The first part of A sounds really good, but then you get down to except as provided in 8511 B and C. And then there's comments there that the entitlement holder's property interest with respect to a particular financial asset, I think Mr. Webb covered that. You don't have a right to a particular 100 shares of stock. Your interest is in a pool. So these are the Oklahoma Code comments. So these were the comments that were included when the legislation was being considered in 1995 for 8503, which is the one that says except as. Hard to read that. I need better glasses. Except with respect to the creditors to whom the securities have been pledged as collateral as provided in 8511. So that's where we're getting back to, is the security, the entitlement holder, the shareholder, would have been a shareholder, doesn't have title to those assets that have been pledged under 8511B. Oh, there we go. Perfect. I'll make it a little easier on my reading. So 8504 is another section that's often used by the folks that want the system to stay as it is, because 8504 very clearly says that the brokerage firm is required to access and maintain sufficient financial assets to cover all of the entitlements that they've given to their clients. The problem is that the second line there, the securities entitlements intermediary may maintain those financial assets indirectly, which is what they do. The brokers don't maintain the assets directly. They're always held indirectly through one or more custodians. And then what that does then is it absolves the broker or dealer for meeting this requirement, but it also puts the initial investor at risk of the credit risk for that higher level custodian. Because if the assets are held by the custodian, I don't have a relationship with the custodian, what they do with it, and if they happen to lose it or go insolvent, trickle, 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 it just doesn't come back to me. I have a claim against the broker who's sitting there without anything as well. And this section also doesn't apply to clearing corporations, which is a pretty big hole in the whole thing. So this is continuing on in your comment. And the comment is, it's not statute, obviously. It's not law in Oklahoma, but courts have looked to statute to determine legislative intent. So to the extent they look to these comments to add context to what the statute says, I think they're important. And this is just that holding may be either direct or indirect. holding through a clearing corporation or another securities intermediary. And it says right in there, customers do not necessarily have priority over lenders with respect to wrongfully transferred financial assets. That depends on 8503 and 8511. So even though this 8504 is often used to prove that investor assets aren't at risk, it just says right there in your comments that they're not protected. And that they can also get by with compliance with reasonably commercial standards, which is a big out. Okay, so let's get to 8511. That's the main section that we're at here. 8511 deals with priority among security interests and entitlement holders. A starts out with the exceptions except as provided in 8511B and 8511C. The entitlement holder has priority to their own assets. So you think, well, that sounds pretty good. That's the way it should be. Then you get to 8511B. A creditor of a securities intermediary has priority over the securities intermediary's entitlement holders. So a bank that lends to a custodian that works for your broker, if they've got control of the assets, they've got priority over those assets, even though you have a contract claim to them as well. And then C simply just says, as Mr. Webb said, that the creditors of clearing corporations always have priority. So the code comment here is pretty important. The highlighted portion there, entitlement holders can prevail against a transferee of a wrongfully transferred interest in financial assets only in limited circumstances. And it really, when you get into the nitty-gritty on that, we can provide examples, it's nearly impossible because of the lack of ability to trace your entitlement holder interest to a specific asset. They are not subject to the risk that the dealer was acting wrongfully as against its customers. And in that situation, they may have rights under the Securities Investor Protection Act. This is another thing that they throw in the comments is all of that above that they said this can never happen. The investor assets are never at risk. But then they said if that impossible never happens, you've got insurance. They wouldn't need insurance if there wasn't the right or the risk of loss. So I think that's important. And then it goes into, to a certain extent, they're protected against loss. The Securities Investor Protection Corporation has got some potential issues in that it's not funded sufficiently to cover a systemic financial crisis that we've been talking about. It's really designed to handle one failure at a time. There's also a question of if the security entitlement is actually a contract, it would not be covered under SIPC. Contracts aren't covered. That was at least the case law up to this point. Margin account argument is a big one. They throw this out there, as Mr. Webb has said, that if you make this change or if you adjust this at all, individuals won't be able to have margin accounts. But margin accounts and securities lending have been around for decades, been longer than I've been alive. They were not formed when this 1994 Article 8 revision was in there. They were prevalent beforehand, they can be prevalent after. And if that is a concern of the legislature, it could be drafted in there to specifically exclude margin accounts or securities lending if you wanted to. And in fact, that's what happened in an earlier draft of this section. The drafting process for these uniform laws usually goes over a couple years, and they go through, just like you do in your committee work. You're making changes and revisions, and this one did go through there. In an earlier version of this had the term "or the entitlement holder's claims are securities carried in a margin account." So the number one up there is essentially what your current statute says, but an earlier draft of this had an "or" and then defined margin accounts. So the drafting committee clearly didn't think that number one covered margin accounts because they put margin accounts in the number two. Why it wasn't removed, no one really knows, except the drafters. So your code does not limit itself to margin accounts. The term margin or margin account doesn't appear in statute. It only appears in this comment. Securities lending doesn't appear in the statute. So the exceptions that you've included into your statute are much broader than just margin accounts or securities lending. They cover everything. So that's kind of our point, is that if we want to take the interest of the individual investors more seriously, we can focus on narrowing those exceptions or defining what is and isn't excluded. If margin accounts are a concern, you can certainly address that. So as Mr. Webb has said, our position is that all securities essentially are being used as collateral at a higher level, and that the risk of loss is very real. And I want to get to this one just in interest of time. The risk we're warning about here was acknowledged by the drafting committee in the 1994 Article 8 revision. And this is in your comments as well. Thus, unless they acted in collusion with the dealer, persons who provide secured financing to securities dealers to obtain control of a particular financial asset are not subject to the risk that the dealer was acting wrongfully against its customers. In that situation, the customer may have rights under SIPC. So the secured lender, who is also in the definition of purchaser under UCC, is not subject. Their rights as to priority over the assets don't require them to understand that their customer, who they lent the money to, acted appropriately. Even if they didn't, the creditor is protected. I just get into SIPC. I won't go into that. I already addressed that, but it's just, I like raising it because the argument is that this can never happen. Your assets are never at risk, but if it does happen, you've got insurance. There's additional information available. Obviously, we know that this is a topic that's not top of mind for most of us, the UCC in general. And Article 8 is probably the least understood article of all, well, now 12 articles in the UCC. But we're happy to answer any questions. We'll reserve some time for that.
Thank you so much, Don. And up next, we have Jack McFerrin with us. He's a research fellow and editor with Heartland Institute. Jack, you are recognized.
Thank you, Mr. Chairman and members of the committee, for inviting me to speak here today. I've been working on this issue for nearly a year at this point in my capacity as a research fellow at the Heartland Institute, which is a nonprofit think tank located in Arlington Heights, Illinois. What I'm going to do first is I'm going to read from a short policy paper that I put together earlier this year that provides a general overview. Some of it will be relatively redundant on things that Mr. Webb and Mr. Grande have already covered. And then I will recap much of what has been talked about here today. So, important provisions in Article 8 of the Uniform Commercial Code contain highly problematic elements that undermine Americans' individual rights and threaten the stability of the U.S. economy. The UCC was created in the mid-20th century by the Uniform Law Commission, an influential organization of practicing lawyers, judges, legislators, legislative staff, and law professors. The ULC frequently proposes updates and revisions to the UCC, and it, along with the American Law Institute, is the driving force behind the vast majority of UCC legislative proposals. According to its website, the ULC provides states with nonpartisan, well-conceived, and well-drafted legislation that brings clarity and stability to critical areas of state statutory law. The ULC notes that the Uniform Commercial Code is a comprehensive set of laws governing all commercial transactions in the United States. It is not a federal law, but a uniformly adopted state law. Uniformity of law is essential in this area for the interstate transaction of business. Because the UCC has been universally adopted, businesses can enter into contracts with confidence that the terms will be enforced in the same way by the courts of every American jurisdiction, and for this reason, the UCC has been called the backbone of American commerce. As the ULC has rightly explained, the UCC is a vital set of laws that allows for commercial activity to be conducted in a relatively cohesive manner across all 50 states. Because commercial activity and technology are always changing, it is prudent for lawmakers to occasionally update the UCC. Unfortunately, because the UCC is dense and complicated, very few people and organizations understand it. Over the past few decades, the ULC and others have taken advantage of this confusion by implementing changes to the UCC that few people in the public fully grasp or even know about. Furthermore, because the ULC has a long-standing positive reputation among state legislators, policymakers have made these changes to the UCC that have been proposed by the ULC without fully understanding the ramifications of their decisions. Perhaps the most egregious example of this relates to amendments made to UCC Article 8, which focuses on investment securities. These amendments, which were passed in the 1990s, have abrogated Americans' property rights to their own securities, including, but not limited to, those contained within retirement accounts, such as 401k and IRA accounts. In 1994, the Uniform Law Commission established a drafting committee to revise UCC Article 8. The ULC revised Article 8 and then presented its amendments to state legislatures. Over the next several years, lawmakers in all 50 states, as well as the District of Columbia and Puerto Rico and the U.S. Virgin Islands, passed those important amendments, fundamentally transforming property rights related to investment securities, including stocks, bonds, ETFs, and most investments included in retirement accounts. The stated rationale for the revisions was that the previous version of UCC Article 8 did not address the rapid evolution occurring in the financial sector from paper stock and bond certificates to digital uncertificated securities. The transition began in earnest in the 1980s. Moreover, the lead drafter of the 1994 UCC revision stated that the primary motivation behind the work was to prepare for a potential collapse of U.S. financial markets. Under the revised UCC Article 8, individuals, organizations, or businesses that purchase a security investment are no longer the owner of the security. Instead, they become the owner of a securities contract called a security entitlement. The revisions to Article 8 shifted ownership to the purchaser's broker, or more commonly, to the organizations holding securities in trust for brokers, bankers, and other financial institutions, the most prominent of which in the United States is the Depository Trust Company. The DTC is owned by the Depository Trust and Clearing Corporation, or the DTCC, which is, in turn, owned by the participants of its various subsidiaries, including the DTC. DTCC's participants are primarily banks, brokers, and other financial institutions. The DTC holds 1.4 million securities valued at $87.1 trillion, making it one of the most important financial institutions in the world today. The DTC holds securities in pools rather than registering each security to a specific purchaser. By allowing ownership to shift to large financial institutions, especially the DTC, and permitting securities to be pooled together, the UCC and the federal government have empowered brokers and other institutions to use other people's investments in a variety of financial arrangements, including short sales, that otherwise would not be possible if the original purchasers maintained ownership of their investments. Ultimately, the changes to UCC Article 8 have helped guarantee that the protected creditors of these securities intermediaries are given priority ownership to security entitlements when intermediaries, such as popular stockbrokers, use customer assets as collateral. What this means is that if an individual investors were to go bankrupt, the broker's secured creditors, large financial institutions, would be given priority over individual investors who made the mistake of thinking that the security they bought and paid for belongs to them. In such a situation, Article 8 ensures that the investor would become an unsecured creditor with the investor's claims to their securities falling at the back of the line in an insolvency proceeding. That means that in the event of a wide-scale financial crash, thousands or even millions of investors could lose a significant portion of their assets to secured creditors. Further, there is simply nowhere near enough collateral to cover all of the debt and other obligations currently spread throughout the financial markets. So the risks to individuals posed by Article 8 are real and they are dire. In order to alleviate concerns about investment markets, Congress created the Securities Investor Protection Corporation, the SIPC, in 1970. In the event a broker goes bankrupt, the SIPC would, under most situations, bail out investors up to $500,000 in securities and cash, although the limit for cash is $250,000. Unfortunately, the SIPC has been vastly underfunded for years and could not even come remotely close to covering investor losses in the event of a widespread market failure. At the end of 2021, the SIPC fund had approximately $4 billion in assets, a tiny fraction of what would be required in a significant crash. For example, Fidelity Investments alone has approximately $12.6 trillion in assets under management. A review of the current UCC, contemporaneous writings by law professors, the ULC drafting committee's comments, and a simultaneously enlightening and concerning exchange between the U.S. Federal Reserve Bank of New York and the European Commission's Legal Certainty Group clearly indicate that the threat posed by Article 8 is real. Further, there has already been an instance in which the changes to UCC Article 8 were used as the legal basis for the taking of investors' securities. These legal decisions have cemented into law the assertion that large financial institutions have priority over customer assets. When Lehman Brothers filed for bankruptcy during the 2008 financial crisis, one of its primary lenders was JPMorgan Chase. A subsidiary of JPMorgan Chase was Lehman's custodian of both Lehman's own assets and the assets of Lehman's customers. As custodian, JPMorgan Chase had control of Lehman's assets, and as lender, JPMorgan Chase had a security interest in Lehman's assets. As a result of the changes to UCC Article 8, as well as a 2005 change to federal bankruptcy law, JPMorgan Chase was able to freeze Lehman's institutional accounts as collateral for the loans that Lehman could no longer pay. If the financial markets continue to operate without significant trouble, the changes made to Article 8 will likely have little impact for individual investors. However, if there were a large crash in the financial markets, investors' securities could be taken in the aftermath, all to the benefit of too big to fail financial institutions. So, to recap here, changes to Article 8 completely abrogated property rights to investment securities of individuals and gave them to the secured creditors of securities intermediaries. Those secured creditors are typically the world's largest banks, contrary to what the ULC asserted in its letter that was read this morning. In the event of a financial crisis, Oklahomans could lose everything to these too big to fail financial institutions. This concept has already been proven in court during the 2008 Lehman Brothers bankruptcy. There is nowhere near enough insurance capital to cover investors' losses. The ULC and the banks that they serve have erased nearly 400 years of law surrounding personal property rights, which is completely antithetical to individual liberty and the values this country was founded upon. Ultimately, while protecting Oklahomans' securities in the event of a crisis is vitally important, it is equally important to understand that Oklahomans' rights have already been gone for 29 years. The next step is taking the property itself. Lastly, it is important to understand that the Uniform Law Commission is not a friend of Oklahoma. It is not a friend of the American people. It serves special financial interests to the detriment of society, and everything they advocate for should be treated with extreme caution.
Thank you very much, Jack. And up next, we have Betty Grande. She is a former state representative from North Dakota and is with the Pro-Family Legislative Network. Betty, you're recognized.
Thank you, Mr. Chairman. Thank you, members of the committee and Representative Maynard. I'm not going to go over any more of this. These guys, I think, really kind of took you down a really nice path. I'll just state that as you dig into this more and as you're looking at this, if you have more questions, you can come through me at Pro-Family Legislative Network. I link these guys all together, so just kind of I'll be the ally that draws that for you, and Pro Family Legislative Network will be here for any other information you may want. Thank you.
Well, with that, we are actually way ahead of schedule, so we have lots of time for questions. And as you have all seen, part of the reason I wanted to host this study is because Article 8 is very complicated. And the derivatives market, the securities market has so many layers that even though I've done my own reading, it takes a lot to start to grasp and comprehend how it works. So with that, if anyone has questions, I'll open it up and we'll start with any members of the committee, and then if all those questions are exhausted, we can move to others who are present.
Vice Chairman Kane.
I'm not sure I know enough to even ask a question. This is very complex. I thought I knew a little something until you started talking. But it was great information. First of all, my first question, as an individual investor, is there any opt-out? Can you still get the certificates? Can you still do that?
There are a couple of, thank you, Representative, for that question. There are a couple options available in some instances. Individual investors can ask for physical certificates. A lot of companies still provide those. They do charge a little extra for it, make it a little less convenient for you, but it's available. But certain investments important to your constituents in their IRAs and 401ks are not available in certificate form. Most mutual funds do not have certificates anymore, and very, very few, if any, exchange-traded funds, ETFs, it's another popular vehicle for IRAs and 401ks, they're not available in certificate form. U.S. Treasuries are not available in certificate form. So for practical purposes, it's listed as a choice on the part of the investor, but it's really a Hobson's choice. They don't have a good alternative.
Vice Chairman Kane, just to ask all your questions. They don't need to be recognized every time. Go right ahead.
Okay, thank you. Next question. If, for example, an individual state, Oklahoma, we amend our Section 8, Article 8? 8. If we, what consequences is that for our investors? Are they going to be ineligible to enter into some trades and into some markets? What happens to our people if we do this?
I have to say it is a big step to take. But mainly because you are, make no mistake about it, you will be threatened by the banking interests in doing that. Practically speaking, there would be no problem. It's just a matter of what threats you will face. So as we see in the case of the Swedish system, it is entirely possible to have direct interest in your own property, even with an indirect holding system. It's a matter of the choices made. The approach Don developed to amending the UCC is elegant. It's very simple. It is simply, so we're told that the entitlement holders have priority over the secured creditors of the intermediary. You simply put a period behind that. You strike the exceptions that the secured creditors, if they have control, they have priority. That's really what is operative. You strike the exception that the clearing corporations have priority over the investors. And that would take this back to, while you still have the concept of an entitlement, you return this to what people were told they had when this was put in place in 1994. So this can be done very simply and elegantly. But what we see is that the banking lobbyists will outright threaten you that bad things will happen if you make this change. That will just, as I said, to the people in Tennessee, you will have to decide if you like being threatened, how you feel about that. It's a matter of what they will threaten is that they will withdraw financial services from the state. That will have to be faced down. I think that itself is illegal. Even to threaten that is illegal under anti-racketeering charges. This is a pattern of criminal behavior, quite frankly. It can be done, but I think you have to have enough people within the state that are willing to stand up against it. Now, what would it mean? This has now been a year that people have been looking at what I exposed here. It's been thoroughly examined by people globally that this is the situation. And I've had people that have contacted me that have said, if you could figure out any jurisdiction in the world that could protect people from this, let us know where that would be. Now, think about it. If the state of Oklahoma, everyone is concerned about real asset protection. If the state of Oklahoma were to make this change to stand up against the banking lobby and make the change, what does that do? In the present situation, the secured creditors have priority in these pools. If you simply reverse this, now any investors in the state have priority to their own assets, but that puts investors in this state structurally ahead of the secured creditors and actually gives a super priority to investors in the state of Oklahoma to all the pooled assets. Now, what that means is that other states will then want to follow and copy that. And what would happen in the financial complex is that these banking interests would be forced to begin unwinding this massive derivatives bubble, begin settling it down. Now, it can be done. In Europe, there was something called the Bank Resolution Authority, created following the last crisis. And they have these planning cycle documents each year. And in their 2022 document, they mandated that the biggest banks would be ready to go flat on their derivatives books very shortly in a crisis, essentially front-running the market, that the biggest banks would be prepared to do that. In their planning cycle document for 2023, they said all their work would be completed by the end of the year. So this was just last year. So they can do that. They can reduce this risk in the financial system. So I think those are the simple points. It can be done, absolutely. We can face up to it. It can be done. The first jurisdictions that do that will actually have an advantage globally if they've done it. And the banking system can begin doing what sane people should do. But we have to help them.
Last question for now. So if I'm understanding you, and this may be a question for the lawyer. So let's say you go back to Lehman Brothers, and if we had already amended this, you're telling me that Oklahoma investors will be treated differently because of our law in our state?
Correct.
So, and I, as a former community banker, way below this level of stuff, but the Uniform Commercial Code was important and beneficial to us. I mean, I liked it.
Yeah.
It gave us, certainty of our perfected interest in different assets.
Yep.
So are you basically saying they've taken this, what once I considered a very good tool, and just gone a step too far, and now it's harming? Is that what we're hearing? And so
Yeah, yes.
If you can answer all of that, I'd appreciate it.
Yes, Mr. Representative, that is what we are saying. For bankers, the UCC is the Bible. You know, you rely on that because you need to have certainty because bankers don't like risk, right? And I'm talking community bankers primarily. The UCC Article 4 and 5 revisions from the early 80s was the first example of a sort of a takeover of the process by special interests, the attorneys that work for the big banks, and that continued into the Article 8 revision in 94 and then into the UCC 2022 amendments for Article 9 and 12 that I believe you guys passed a form of last year. But yes, that's what we're saying is that in the court documents of the bankruptcy case, the reporter reporting back to the judge specifically said that it's state law that says what is and isn't in the bankruptcy estate. So if your state law doesn't allow the assets to get into the bankruptcy estate in the first place, they're protected. Obviously, I know how the world works. I'm not saying it's going to be clean and it's going to be done overnight, but legal title to those assets would remain in the name of the Oklahoman individuals. So, yeah.
Other questions, committee members? So if I've heard, I'll ask a couple. So if I've heard this accurately and was to translate this into maybe some different language, unwinding this forces, well, the institutions that are taking advantage of this, basically this structure allows them to, whether you consider it criminal or not, engage in riskier behavior, right? So if you unwind this, they would engage in less risky behavior, but what you're doing is protecting the individual's property, right? At the top of this chain of events that could happen if a bad thing happens. And so it's really about a transfer as risk is how this is set up, and unwinding it broadens the risk. Is that a fair statement?
Mr. Chairman, in a sense, unwinding this does a couple of things. And you think back, there is a combination of state law and federal regulations, the SEC and the Investor Protection Act and all of that, and they do sort of cover different areas and bounce off each other. But in my mind, as I've been looking at this, state legislators are putting an awful lot of hope in the federal regulators that everything's going to be fine and that they're kicking the tires and everything. But just the most recent financial crisis, well, the 2008 housing crisis, you know, most people at that time, that was primarily mortgage-backed securities, that the housing bubble was going up and they were carving up mortgages into different securities and selling them. Most people thought that a mortgage-backed security would have to have a mortgage backing it. But when the cards all fell, they found out in many cases there were no mortgages backing the mortgage-backed securities. As one woman I follow says, there was no M, just BS in the MBSs. And so the idea that there's somebody out there that's playing cop and looking out for these things is not factual. Nobody went to jail. Nobody paid a fine or anything. They all got their bonuses. So unwinding this from the state level will be at least an attempt to put some accountability back on the financial markets, because right now they seem to be able to do whatever they want with whoever's assets.
Yes, sir, go ahead.
I have to say it's actually very simple, shockingly simple, which is it's about certainty of who controls the collateral. It's as simple as that. That's what has been shifted elsewhere. That's what has enabled all of this very bad behavior to happen. And it cannot be addressed without placing that back where it should be, that people have control of their own property. Property is profoundly important, rights to property. It is deep in all animals having a place, having security It relates to the ability to reproduce, actually. If you lose property rights, it really is very damaging to people. And of course, it relates to autonomy, individual agency. It is absolutely foundational. So if this can be put back rightly, and it can be done simply, I'm not saying it's not going to be opposed, because they have free use of all this collateral. They are not going to willingly give that up. You know, they have no reason to cooperate with this. So it is up to people in the states to decide what they're going to do about this. There's not going to be help from the federal level. The answer isn't going to come from there. It is not going to happen in Europe at the EU level. Absolutely not. The individual states in Europe will not stand up against this. The only place it's going to happen, and I've seen it in coming here with these processes, it is possible in the states.
So I may have misunderstood some of the concepts you guys laid out this morning. Does placing the individual's property right above others, everything else, change the dynamic in terms of the pooling concept? Can you no longer then use the pooling for collateral, or is it just the backside of it if there's some kind of collapse, and then who gets to claim what?
I think, you know, the approach that Don has developed here is to leave in place the concept of the entitlement, but just to put very simply and elegantly assure what was originally promised when this was promulgated originally. The banking lobby will, to reassure people, will read this initial statement that entitlement holders have priority over the secured creditors of the intermediary. We just essentially all the plumbing can remain in place. That's why, in a sense, this is not a radical thing to do. The system can continue to operate largely as it has. DTC can still be there. This is actually a very conservative way to do this, to begin reversing it. So they can remain pooled, but the investors have priority to their own assets, which will then force the higher level to not use their assets as under their own trades. It will. So it's a simple, elegant way to do it.
The Uniform Law Commission, you mentioned its composition was assortment of attorneys and folks from all over the country. Are they, so I think they're simultaneously helping write the code as it's altered over the years, and weighing in on the benefits of the code as it is, right? I would add, well, I think I've looked up who Oklahoma's membership is on that before, and I think one of our colleagues in the House is currently a member. So, Representative, I anticipate you are thinking about legislation going forward with this. I'd encourage you to reach out to your committee colleagues and make sure they watch this recording if they haven't been able to attend this. It'll make your job a lot easier trying to run that legislation, because frankly, this is the kind of stuff that people don't understand, and so they have a choice. I don't understand it, so I vote no, or I don't want to look stupid, so I'll vote yes. You know, that kind of thing, and you really don't want that on something this significant. Just 10 years of experience speaking. So any other questions? Representative Maynard.
So I have a few questions just to throw into the mix. And some of this, again, I have a background in financial management and accounting, but a lot of the people watching or listening do not. So I just want to get a few terms cleared out there. So when we talk about securities and derivatives, could y'all explain it to me like I'm 5 years old? What are those things so that we can make sure everybody understands what exactly we're talking about, the property rights of?
I overruled Mr. Webb on this because his depth of knowledge is a little not really what you were looking for. I think you want more of a general discussion of that. So securities, a security is basically just an interest in ownership of something. So a stock is a security. A bond is a security. Your mutual fund interests are securities. Treasuries, they're all securities. It's just an overall term to describe different types of investments that an individual can purchase for their IRA or 401k. And you said derivatives was the other one. Derivatives is one. We've had this discussion at home because it's a scary word, but it's really pretty simple. A derivative is just a contract between, well, generally between two parties that is it's a contract based on what another asset will do. So for example, like a interest rate swap or something. If somebody's worried about interest rates going up and they want them to go down, they can enter into a contract with another party to say that if they do go up and I want them to go down, I'll get the insurance. The derivative contract will pay out insurance, so I'll be able to hedge my risk. So it's just a contract which is value of the contract is derived from another asset or another group of assets. So that's what derivative means.
Thank you. And so when we're talking about also the Universal Commercial Code, one of the things that I hear frequently is and it is true that the value of the Universal Commercial Code is the uniformity across states. It gives businesses security and makes it easier to operate in multiple states at the same time. However, what I always hear is the Universal Commercial Code is identical in all states, and I would like you maybe to speak as a lawyer, is the UCC in the various states, is it identical or not?
Representative, the Uniform Commercial Code is not identical from state to state. There are some states that haven't even adopted all 9 or 12 articles. They might pick and choose, or they might decide not to take a certain amendment up. And then legislators, obviously, are the ones that are drafting the legislation, not the Uniform Law Commission. So it's up to you to what you want to do. And from state to state, certain things will be tweaked or amended. So it's not necessary that it is uniform. In the writings of the Uniform Law Commission, they call it imperfect uniformity. They want it to be pretty darn uniform, but it doesn't have to be cookie cutter from state to state. And I think that's pretty clear with the way the states handle it. And it does come down to the Uniform Law Commissioners from each state, how involved they are, or whether this particular uniform law is their specialty or not, because I know their colleagues will rely on their expertise and their time on the committee, but it does not have to be uniform.
Thank you for that. And so one of the concepts that honestly kind of scared me a little bit when I started digging into this was I heard if we change our UCC, that all Oklahoma investors would lose the ability to have margin accounts or to trade with margin accounts. And I know y'all have talked about that some. However, not everybody out there knows what a margin account is. And so I'm going to ask a two-part question. Number one, please explain to the public what is a margin account? What does it allow you to do? And then number two, did margin accounts exist before the 1996 UCC code modification? And if so, how? How did they exist before that?
I'll answer the how first, Representative. A margin account, well, I guess I'll answer the what first. Margin account is a an agreement between an individual investor and their broker or financial advisor, where they have a portfolio that's worth $10,000. They can lend their assets, or they can borrow from their broker, say $5,000, with their portfolio being held as collateral. That's a margin loan. They're taking a loan basically on the margin, or the percentage that the broker will lend back in the form of money. So it's a secured loan, like going to buy a house, except instead of a mortgage, you pledge your stock portfolio or a portion of it. And margin loans are not, I mean, it's used a lot by the proponents of the current law as argument against us, but you have to think margin loans are a very small percentage of your constituents' relationship with their broker. 401ks and IRAs are not eligible for margin loans. So it's only an individual that has a personal investment account, and then only a portion of those individuals, maybe 10%, would consider a margin loan because they're a little risky. And margin loans did exist prior to this 1994 law because margin loans and security lending agreements or securities lending are all defined by an agreement between you and your broker, or you and whoever you're lending your securities to in a securities lending situation. So there's always a separate agreement. And so that agreement, the terms of that agreement control, regardless of what your Article 8 in the UCC says in Oklahoma. So you can continue to have margin loans. And in fact, if we're right in that we are bolstering the individual property rights, the asset that they actually have to loan is stronger, because right now I have a security entitlement that I'm putting up as collateral. What the heck is that? And what does it do for me? But if I have clear ownership rights, the party on the other side lending me the money should actually feel more secure. So I don't see the issue.
Thank you for that. So, I mean, what's very essential to me is that we protect the personal property rights of our constituents and of Oklahomans. I think everybody wants that. At the same time, I don't want to hamper businesses or the ability for trading to take place. So I kind of have the question of, is there a way to modify the UCC that would protect our personal property rights while at the same time maintaining Oklahomans' access to margin lending accounts and really not mess up the system? That's kind of my goal is there a way to do such a thing where you have your assets protected, and yet we don't cause the calamity that we hear about, because that's not what any of us want. Nobody wants to throw a big monkey wrench into everything and have Oklahomans' ability to buy and sell and trade hampered by our changes.
I'd say it comes. Thank you for the question. It comes down to willingness and cooperation. If there are problems in doing that, it's because someone is creating problems in doing that. There is absolutely no reason that these changes cannot be made for the banking interest to say that there are big problems because people will actually have a claim to their own assets. That really tells you that there is a big issue that has to be faced up to here. So it will be a matter of having adult conversations with the financial interests here when this is done, and gain cooperation, make sure there is cooperation, that there will not be problems. I want to explain an analogy here. The banking interests want people in the financial services industry to believe that they're all in the same boat, on the same side in this. That is a misdirection, because the model for this, by analogy with medieval fortress towns, there was a castle. The castle keep was on a hill. There was an ample city wall around the town. The townspeople were encouraged to settle within those walls, and they felt they were being protected by the Lord in the castle. When the real strategy behind that was that any attackers would have to go through the townspeople before getting to the Lord in the castle. That is the financial services industry. The castle on the keep is the biggest banks. That is J.P. Morgan. The simple townsfolk are the people in the financial services industry that have the responsibility to their clients. And what they've done with this construct is the claims from the clients are against their financial services providers. For example, in the state of Oklahoma, who don't actually have the client assets. The client assets are elsewhere. So we have to understand together that the people in the financial services industry are not being protected by this construct either. And by making it apparent and all talking about it, we can face up to it.
And this is my final question, promise. So one of the things that is important to me is retirees, that their retirement is protected. And so one of the things that y'all mentioned earlier was we do have the ability, if we want to request physical custody of our stock certificates, to do so. But I'm going to say most retirement plans, a lot of the businesses that offer them only offer you mutual fund selections. So in a mutual fund selection, the fund is actually investing now in multiple other securities. And so I'm going to ask the question, if that is the case and your holdings are in mutual funds, does a Oklahoma citizen have the ability to request now ownership of the stocks in the underlying fund?
Representative, the individual would not have the ability to request to pierce through and get ownership of the individual actual securities, the Apple computer shares or whatever. Some mutual funds do allow certificates, physical certificates, or do provide physical certificates. But again, now you're getting another couple layers of complexity here, because you've got a physical certificate that represents a certain number of shares in a mutual fund, mutual fund, which then represents investments in 50 other companies or 100 other companies. So it gets pretty complicated in a hurry once you get into that type of situation where most people hold their assets. Most of your constituents are using mutual funds or exchange-traded funds for their assets. So you can't get through that. That's where Mr. Webb is talking about even the sophisticated investors. And I would put, Fidelity and Vanguard and all those guys in the sophisticated category. Those two might fit the criteria of too big to fail, but a lot of the sophisticated investors is just as much risk as the individual investor is.
I think Representative Schreiber's waving down at the end of the table. You're recognized.
Thank you, Mr. Chairman. So previously you gave the example of the mortgage crisis. Is that the most tangible thing that we have that we are trying to avoid, or are there specific scenarios in which what you're advocating protecting against is occurring today on a regular basis?
Well, while you're kind of pondering the answer to that, we've had other crises. Some of us are old enough to remember the dot-com bubble before in Oklahoma back in the 80s. Oil busted through a bank failure, big bank failure with some questionable practices. So some of us have long memories. You might add that to your answer.
That's a good follow-up, and I will address that. The mortgage crisis, the 2008 financial crisis, is the most recent one for us that was caused by excesses in the securities market. it was out of control. And what they were doing, you just have to watch The Big Short or Margin Call, and you figure out what they were doing was not on the up and up. The COVID-related crises were of different nature, but really, what we anticipate and expect is at some point there will be a systemic financial crisis that would cascade beyond just one or two firms into a larger round of insolvencies, and that's where this issue really kicks in, because they can kind of cover for it if it's an isolated broker or financial institution that goes under. But if there's multiple, there's just nowhere to hide, because as Mr. McFerrin said, there aren't enough assets out there to cover all the loans that people have against them. And to get to Chairman's question, it's a fair question, and we sometimes hear that, this law in Oklahoma has been around since 1996. Nothing's happened yet, right? And so what's the big deal? There's several different ways to answer that. First of all, for me as an attorney, I say something actually did happen right away, because each time one of your constituents bought 100 shares of Apple, they didn't get it. So that happened. But beyond that, the 2008 financial crisis kind of proved the concept of what could happen here with that Lehman Brothers, J.P. Morgan, but it really wasn't time. It wasn't ripe for the entire system to kick in here, because, as Mr. Webb has pointed out, the European Union hadn't fully implemented these changes, and that came 2014, 15. So we haven't had a significant financial crisis since things were ready in place like they are now across the globe. So you can take that for what it's worth. But I remember a fair number of those. I was working in the trust business in 1987, Wall Street crash. Of course, I was only 2 at the time, but yeah, we all have a good memory of what's gone wrong. And our concern here, the main concern here is, as I think both Mr. Webb and Mr. McFerrin pointed out, that as the system is functioning, there is no real impact to the individual investor. They're able to sell the stock if they want to, and if it goes up, they made some money. It's just where there's this systemic financial crisis, and then that's where all the little house of cards starts to tumble.
Representative Stinson.
So would it be fair to say that if we made the change in 8-503 where we left out the exceptions to that, that's not going to have any direct effect on the systemic risk, but by doing that, it'll change the priority of payout, or who collects in the event of a failure, and therefore, you think if we did that these banks would start to unwind some of these derivative contracts, this sort of mesh of things, and if doing that, would that then reduce the systemic risk of all of the interconnectedness of these entities?
Representative, that's a very good question, because the rationale or justification for this 1994 amendment was the 1987 stock market crash. They wanted to have Armageddon planning. So, so you have to think of the Armageddon planning that they're talking about here. What they came up with was something that didn't even address reducing the likelihood of the next financial crisis. All it does is say if or when it comes, the banks are protected. So, unwinding just that part of it shouldn't change really anything as far as they're concerned, I wouldn't think, because their stated purpose was, to protect against the next financial crisis, but they didn't actually do any of that in this bill. They just made sure that when it happens, the banks are protected. So I think undoing that makes the most sense. And theoretically, I'd like to think that will enforce better behavior and less risky behavior. At least the customer or your constituents' assets are protected. That's really the only change that comes out of it. Is I can't change what Wall Street will do, but I can change who gets left holding the bag.
Other questions? Nobody texted me one. So, Representative Maynard, I think we're back to you for closing remarks.
Well, I just want to say thank you so much, everybody coming out. Thank you for all of our presenters for traveling here to present and to help do better education to us on the effects of Article 8 of the UCC. I think we all have probably a lot more homework to do and look into just because it is complicated. However, I think, again, to me, priority is that our citizens are protected, that their investments are safe, that when they go buy something from a bank or broker, that they know that those assets do belong to them at the end of the day. And so that's kind of, again, my goal is to protect my citizens and to protect the citizens of Oklahoma. So thank you all for your time today. With that, we are done with the interim study.
Thank you. I would suggest, Representative, as you encourage people to watch this, they jump to about the hour 40 mark to get the answers to the basic questions, and then come back to the beginning and watch that. For those listening online, we'll be back at 1 o'clock for another interesting study. Representative Schreiber is going to run. And then as a little commercial tomorrow morning, we're going to talk about the impact of pensions on recruiting and retaining public employees. With that, we are recessed until 1 o'clock this afternoon.